often overlooked aspect of financial planning, ensuring your legacy aligns with both Sharia principles and strategic foresight. Over the next 2 hours, we'll explore how Islamic compliant trust and wills can safeguard your wealth for future generations while fulfilling ethical obligations. Before we progress, I would like to just share with you some quick housekeeping steps. We'll encourage everyone to ensure that your questions are submitted via the Zoom Q&A box, located at the bottom of your screen. We're going to address all the questions during the dedicated Q&A session after the panel discussions. Webinar recording and slides will be shared via email within 24 hours to all participants. Our agenda will include opening remarks, from Coronation Trustees leadership. We're going to have a keynote presentation on Islamic wealth succession frameworks, and we're going to have a robust panel discussion featuring industry experts. And finally, of course, we're going to have a Q&A session. To kickstart things, I would like to ask you to join me in welcoming the CEO of Coronation Trustees Limited, Mr. Yemi Sadiq. Yemi will share our vision for today's dialogue and set the stage for this vital conversation. Yemi, the floor is yours.
Thank you very much, Dr. Oyewale. Good afternoon, and good afternoon to our listeners. It's truly a privilege to welcome you all to today's conversation on strategic wealth succession, a halal approach to trust and wills. It's a very important conversation, and at Coronation, we've always believed that estate planning is not just a financial exercise. As a matter of fact, it is an act of intention. It's an act of responsibility. It's also an act of legacy. And what we've decided to do is that today we will go a step further to explore what that means through the lens of faith, through the lens of family and Sharia compliant principles. Now, we know that questions around wealth transfer, family continuity, and religious compliance can be a little bit complex, but they don't have to be avoided. As a matter of fact, if you approach them with clarity, if you approach them with cultural sensitivity and legal precision, as you would be hearing from all our panelists, you would see that these issues can actually become powerful tools to shape intergenerational harmony and economic empowerment within our communities, especially within the Muslim Ummah. Many of us know the saying where they go, wealth is a trust, and in that trust lies the duty to preserve. There's the duty to distribute justly and also to ensure that our values endure beyond our own lifetime. So this webinar was really born out of a simple but very urgent observation that a growing number of Muslims, particularly in Nigeria and across Africa, are seeking structures that reflect both sound financial planning and religious adherence. Yet, the tools to make this happen, from an Islamic will to a halal compliant, trust point of view, are not as widely understood or applied as they should be. And that is why today's session matters to all of us. So today we're joined by an exceptional panel of scholars, legal practitioners, wealth advisors, lecturers, thinkers, CEOs, whom Dr. Oyewale will be introducing in a bit. They will help us unpack not just what is permissible, but how it can be structured meaningfully in today's world and for today's family. So whether you're a professional advising clients or a family steward planning ahead, or someone just simply curious about aligning your faith with finance, I'll just like to say to you, congratulations, you're in the right place. So let's have the kind of conversation that will help us plan wisely, to live intentionally, and to also leave a legacy worth inheriting. Thank you again for participating in this session, and I think we can begin. Over to you, Dr. Oyewale. Thank you.
Thank you very much, Yemi, for that wonderful introduction. I think you've really explained to everyone, why we are here today and why everybody should pay rapt attention to the session we're going to have today. We are really, really grateful as well for the quality of participation we're already seeing on the line, including our 80-year-old icon of the stockbroking profession, Alhaji Rasaki Oladejo. We appreciate you, sir, for joining this, and all the other members of the public that have joined this session today. I would like to introduce our keynote speaker, Mrs. Fatima Datijo Mohammed. Anybody that knows Mrs. Fatima Mohammed will know that she is a versatile professional with significant experience and practical knowledge in business advisory, alternative dispute resolution, corporate practice, and commercial transactions. She has recently developed additional competencies in competition law practice and Islamic finance. Ajia Fatima Mohammed is a senior associate at Duale, Ovia, and Alex Adedipe, the firm, with primary placement in the business advisory practice group and secondary placements with the competition law, real estate, wills, and trust practice groups. With over a decade in top legal roles, prestigious membership in legal associations, and engagement in diverse practice areas, Fatima has advised notable government parastatals, individuals, multinational companies on commercial transactions, regulatory compliance, and stakeholder management. She has participated in numerous trainings, seminars, and conferences on continuing legal education, mergers and acquisitions, Islamic finance, leadership skills, and acquisitions within and outside Nigeria. I will be pleased to actually ask you to allow Ajia Fatima, to share with us her views on this very, very interesting topic. Ajia Fatima, please, you have the floor.
Thank you very much, sir. Good morning, everyone. Assalamu alaikum wa rahmatullahi wa barakatuh. And it's my singular honor to be here and to be on this platform to discuss a halal approach to trust and will. So permit me to share my screen. I have a presentation. Okay, so the topic, or rather the discussion today, is going to be centered on the strategic approach, halal approach to trust and wills. And the keynote topic, which I would be discussing today, is the strategic importance of halal wealth succession. And without further ado, I would just go through my outline, the introduction. We have the importance of halal wealth succession. We have Sharia compliant wealth succession strategies. We would now delve into these strategies, which includes wills. We would have an exhibit of the will. We would now discuss modern applications of this succession strategies, and we would talk about why we feel there should be a practical guidance for planning. We will look through a few Sharia compliant tools and make some recommendations, and then we would discuss the benefits of halal succession before I finally conclude, and we would delve into the main discussion for the day. Just like Mr. Yemi Sadiq mentioned, we all know that wealth is an amana, right? It's something that we keep on saying, and I know everybody knows that once you're giving something, you're entrusted with that to take care of that, and also to utilize it in a way that is pleasing to Allah subhanahu wa ta'ala, and to make sure that it's distributed or utilized in a way that progresses yourself, your family, and the community at large. So today's discussion, we're going to explore how we approach wills and trust from the halal aspect. We all know what a will is from the conventional term, but this time around we're focusing, or rather we're shining the light on how wills and trust and Islamic wealth management is being looked upon from the halal or Islamic point of view. Okay, so why does halal wealth succession matters? We've already said that wealth is a trust. And once you're entrusted with something, obviously you have to ensure that you do justice to that. That is captured in chapter 57, verse 7 in the Quran. Equally important is the fact that when you manage or you you do things, or rather you sort of strategically align your wealth so that it succeeds not only yourself, but your future generation. It prevents any form of dispute that may arise. For example, in a situation whereby you decide to alienate some parts of your family members from benefiting from the wealth that you have been gifted by Allah subhanahu wa ta'ala, that sort of brings some level of family discord after your demise, and you do not want that. So the best way to go about, handling issues like this, aside from the conventional, or rather the mandated Islamic law of inheritance, which is in the form of fara'id, which I would come to discuss subsequently, we have a way to ensure that you are able to maintain the situation in the home. We already know that there's a stipulated mandate of how wealth is to be shared. However, Islam also affords you the ability to give out certain parts of your wealth to benefit others that may not be part of your Islamic heirs. Another thing why wealth succession matters is that it aligns with the provisions of the Sharia. And aligning with the provisions of the Sharia affords you to be in tandem with Islamic teachings. It affords you, it stops you from engaging in riba, in gharar, in injustice, or the likes. And most importantly, it ensures that you fulfill your Islamic duty as a person. So what are the strategies that we'll be looking at? First of all, we're going to look at wills, which is, in other words, called wasiya in Arabic. We're going to look at faraid, which is the Quran mandatory shares that have been stipulated in the Quran. We're going to look at hiba, which is a gift. And this is when you gift, you give out part or a portion of your wealth whilst you're alive. And then we're going to look at waqf, which is a perpetual charitable endowment, which you can give for charitable causes. And then we'll look at trust for the benefit of minors and other vulnerable dependents. So we can go into will for now. What is a will, right? A will is a legal binding instrument, right, that affords one the opportunity to not only dictate how he wants his assets or wealth to be shared, but also affords you the ability to stipulate how you want certain things to be conducted upon your demise. Say, for example, and which is one of the things that most people are not usually aware, you are able to determine how your funeral or your funeral rites or burial rites can be undertaken. I know for a fact that some of us have been, aware of the recent passing of one of the notable people here in Nigeria. May Allah rest his soul, in the person of Alhaji Aminu Dantata. And one of the key things that his passing actually has brought to light is the fact that, he made it known that he wanted, as the last wish of his, was to be buried in Saudi Arabia. And thankfully, Allah made that possible. And for whatever intent and purpose, it fits into our topic of discussion today. And it's a very good example that everybody can, cherish at the moment. So not only does having a will stipulate how you want to share your wealth, but it gives you the right to dictate how you want things to be conducted, especially your burial rites. It also affords you the opportunity to dictate the guardianship of your children. It gives you the ability to also give, most importantly, a portion of your wealth to somebody who is not a Quranic heir. And that is most important. However, with a caveat. And that caveat is you can only give out up to only 1/3 of your wealth to be allocated to somebody who is not your direct heirs. And those heirs are also not, you cannot also give them a part of that 1/3 because they're already benefiting. So you cannot give them more, and nobody can have more nor less of what has already been stipulated. So what a will does is it gives you that opportunity to give and to also stipulate the modes. It's exhaustive, but I'll just try as much as I can to keep within the context of what is easily digestible, and then we would go into further discussions about that. I would like to give a case study here. So for example, Fatima, a widow with adult children, wishes to leave part of her estate to a long-time household who is not an Islamic heir. She uses a wasiya to allocate 1/4 of her estate to the household and ensures the rest is distributed according to faraid. What that does is basically affording her the ability to give out a portion of her wealth to somebody who ordinarily will not benefit out of her estate. So what that does is, for example, we have quite a lot of relationships that, you know, we have during our lifetimes. They might not necessarily be direct related to us, but we still want, probably we care for them so much and we feel that, oh, okay, they need a part of our wealth to help them ease into the world, you know, after our demise, because most of us probably might have been caretakers thereabout. So we decide to say, okay, look, because I have this sort of relationship, I would want this person to have a portion of my wealth. And that's one of the key important issues that wasiya helps to do. So on the screen is a draft, or rather a pictorial, a pictogram of what a will can entail usually, right? You have some portions where it states, obviously you have to have the testator, you have to have a list of the items that you would be giving out, you have to also have the beneficiary, but most importantly, you also have to have an asset inventory, which is supposed to be captured within the document itself. I will not delve into that deeply, just for want of time, but we would definitely, you know, go further deeper into this discussion subsequently. So that leads me to talking about the mandatory shares that have been provided for in the Quran. And this has been captured in chapter 4, verses 11, 12, and 176 in the Holy Quran. And we're aware that these are all stipulated fixed shares that obviously you cannot change, you cannot circle around. It's something that has to be, adhered to. And for whatever you intend to do, you cannot also disenfranchise these particular dependents or ascendants of yours from benefiting from your estate, because that has been mandated by Allah subhanahu wa ta'ala. And it obviously, we can also look at a case study that I have also shared here. Zainab passes away and her children find that she has not written a will. Her debts are paid. She has not left any wasiya dictating any part or a portion of her wealth is to be handed over to anybody. And so upon her passing, which is the norm that it's usually abided with, her wealth is entirely distributed in accordance with the provisions of the Quran and Sharia, basically. So in that, it's not wrong in just adopting, in not having a will, right? Because whether you do have a will or you do not have a will, your key heirs will still get a share. However, having a will affords you the opportunity to go a step further to cater for other things that may not necessarily be catered for upon your demise. Okay, so leads me to the next, which is gifts, right? Gifts are voluntary transfer of property or assets to another person. When you're giving something out to somebody, whatever that is, you have to ensure that there are certain things that need to be present to ensure that you keep up to, sorry, somebody came in. You ensure that whatever asset you're actually giving out does not also contradict the provisions of faraid. whatever it is you're handing out, you cannot decide to gift your entire asset, whether for charity or for other purposes, because what that does is it ends up, disenfranchising your key inheritors. It puts them in a position whereby they may have to suffer some level of inconvenience upon your passing, especially where you have instances where the person is the sole provider of the family. Upon that person's demise, they may be faced with challenges on how to continue to take care of themselves. So it would be unwise to say, because you want to, probably benefit or give somebody a particular item, you decide to say, okay, you're going to transfer your entire estate to somebody without considering your immediate family. But most importantly, we are also taught that the best gift you can give is from within, right? And it starts with our families. So why would you want to go outside to gift somebody and disenfranchising the same people that would, is most beneficial to? So with gifts, and one of the key things I need to point out with hiba is hiba makes it inalienable. When you gift out, when you give a gift, so to speak, that gift becomes whoever owns or rather takes up ownership of that particular asset. It becomes inalienable. Upon your passing, that person does not have to return whatever it is that you have given that person. So whether you're alive or whether it is within when you're alive or when you're deceased, that gift keeps on subsisting and it becomes that person's, it forms his own estate. So it doesn't revert to your own estate after your demise. So, and what that does is it gives that sense of finality and it gives that level of assurance. So whenever that person, or rather includes that particular asset into his own estate, it forms a part of his own estate without necessarily, reverting back to whoever gave that particular asset to. So what that does is it also forestalls any form of dispute that may arise from either the initial beneficiaries, heirs, from your own heirs as well, so that there isn't any form of discord that can come up subsequently in terms of title or ownership and stuff like that. So waqf, quite a lot of people, have heard, about waqf here and there. And, some people mistake waqf with gifting sometimes, right? However, the key difference I would say between waqf, which is endowment, is that this is when you alienate a portion of your asset to be used for a religious or charitable use, right? And what that means is that whatever value that asset gives, it's basically for your own benefit, which is, as we understand it to be, sadaqah tijariyah, right? And this is something that is perpetual. It does not stop. It's supposed to be a gift that keeps on giving. Whether, upon your demise, it can be intergenerational and until probably we all cease to exist, anymore. And so what it does, it helps in the construction of a lot of things, maintenance of mosques, constructions of houses, orphanage homes, and the like, schools, etc. And it's usually for a dedicated purpose, right? So one of the key examples I would give is, for example, I decide that I want to have a building to be used to shelter orphans. And with that sheltering of orphans there, I do not want anybody to come to take over the management of that asset after my demise. So I tie it to a particular, I can tie it to a particular asset too that generates revenue. So what that does is it helps you in maintaining the the property, whilst also ensuring that there isn't any form of interference. I can also give you a case study that I have shown here, which says Ahmed sets up a Waqf to fund an Islamic education in his community. The Waqf also includes an income from a rental property that continues to benefit generations after his death. So what that does is, despite the fact that you have alienated a property for the benefit of that community, aside from that, you can have, properties that might be run down. There are a lot of things that, can come up in conventional times. You have to pay probably ground rents. There are a lot of things that can come up. However, what that does is when you provide an income that it sort of helps in sustaining that particular alienated property without necessarily having another person come in to foot the bills and also, imputing so much hardship on another person to sustain it. So what an endowment does is it helps your gifts to become self-sustaining and keeps on, it regulates itself. So when you're going to have an endowment or a Waqf set up, you have to ensure that that Waqf is set up in a way that it is foolproof. You do not have any lapse or gapses that allows for instances where you may have some sort of discord or issues that may arise after your death, and you do not have issues that stops other people from benefiting from that alienation that you have done. I was supposed to have taken this order of distribution after death initially, but I think it's come up now, so we might have to do that. So we're all aware that upon anybody's demise, the first things that have to be taken care of is the funeral expenses. Luckily, most people, offer such funeral expenses as sadaqah to the deceased. So not a lot of people understand that the funeral expenses are supposed to be borne by the deceased themselves. However, in that, when anybody, affords you that, it's fine, obviously. The next thing, order of distribution after that, is debts. We're aware that whenever anybody passes, the deceased family are always, communicate to say that, okay, please, can you let us know if so and so, has left behind any debt that we need to take care of, because that's very key and very important. And then we now go to whether or not he has left behind any specific wasiya, which is a will dictating whether he wants a particular portion of his wealth to go to distribution, either via a hiba or a waqf, or also just a trust set up for other members of his family, say his grandchildren and other people who may not generally be his Islamic heirs. And then lastly, it goes to the fara'id shares, which is the mandated Islamic inheritors. So modern applications in finance. I think we've already discussed hiba and will writing. That's one of the things, the most common one is obviously gifting and will writing. Quite a lot of notable banks offer this, this particular services, and I think Coronation Trustees does that also. They provide a guide in how to, write and also write a foolproof will. Bank Muamala, Islamic Wealth Management. These are usually a combination of different wealth management tools which banks have, and I think Coronation Trustees would be able to also expound on a few of these subsequently. Amana Raya, we have Sharia compliant trusteeships. These are trusts that are being made for probably young children, and then the bank is also able to structure such trusts that these the dependents are able to benefit upon when they reach a particular age or they reach a particular station in life. We have Takaful linked investment plans. Takaful here is what is called insurance. You can normal parlance, you can say insurance, right? However, insurance without the risk, right? And what that does is, this is where you are able to do a contribution to safeguard yourself against either any form of ill health subsequently, or in the case of death, and then you want this particular.
Ajia Fatima, you've got 2 more minutes. That's fine.
I'm sorry, I would try and sum it up. When you have instances of death, or you have instance of ill health, you're able to use that pool fund to support yourself. So when you have insurance, you can have some of these contributions in a way that, aside from the fact that it covers such instances whereby you can become incapacitated, you can also use that to create a plan for a trust for your children as well. You also have Sukuk, asset-backed Islamic securities that we're much aware of, I assume. So what would be the guide for planning? I would say we should start early. It's never too late. Once you have the right mental capacity, you should start early. You should seek guidance both from a legal and Islamic point of view. Most importantly, educate your family. They need to understand and also consent. Document clearly, update your asset inventory as often as possible, and then use technology. Technology is your friend. It makes things easier, and it's able to store and guide you and remind you of any alienation you have made so far. Yeah, so I think I have to go off now. Thank you so much. Okay, benefits of halal succession. It prevents the family, gives barakah in your wealth, it empowers future generations, it fulfills religious obligations, and yes, planning our estate, it's an act of faith. It promotes family unity, it honors divine law, and it leaves behind a legacy that pleases Allah. And may Allah guide us in managing our wealth with justice, wisdom, and piety. And Jazakumullahu khairan for your attention. Thank you.
Yeah, Wayakum. Thank you so much. Thank you so much, Ajay and Fatima. I mean, we are really, really grateful for what you've been able to share with us. We know the time was not long enough, but I think you've been able to give us a lot to chew on. You know, there are a few things you said that were so relevant to what we are discussing today. You know, number one, you asked us to start early. You know, I think that is extremely important. We are told in the Quran as well, and in the Hadith, that the Prophet ﷺ has already told us that whoever asks anything worthy, you know, to be bequeathed should not sleep for 2 nights without writing a will. You know, so what that means is that anybody that has anything that you can wish to transfer to someone, please, you must do it within 48 hours once you have the assets. You know, I know a lot of us will be saying, no, I don't have enough assets and all of that, but we know the reality is we all have assets that we can bequeath. So please, let's keep to what she said, you know, and it's important to also seek expert opinion, seek guidance, you know, and that's part of the things we are doing today. That's what Correlation is bringing to us, allowing us to listen to experts like Ajia Fatima. We're going to have a very robust conversation with our panelists shortly as well, you know, and it's also important that we educate our family, let them know that when you write a will, that's your decision. Nobody should be questioning you as long as you comply with the dictates of the Quran, and you also have the right to use your 1/3 as you like to distribute it. You know, so I would like to thank you again, Ajia Fatima. Before we progress to the panel, there is a short poll, you know, that Coronation will put on now that I would like us to just participate. So if you could have the poll on now, please. Thank you. Just very quick questions. Let's participate and let's just click. It's relevant information to the organizers. So while the poll is going on, I will try and introduce our panelists, you know, our distinguished panelists, starting from Dr. Misbah Alamun Latif. It's a real pleasure that we have that someone of the caliber of Dr. Lateef is joining us today. He's someone that we are all proud of, based on what he has done for Islam and what he has done in terms of his academic qualifications as well. So Dr. Musbah Lateef, is a very, very revered lecturer. He's someone that lectures law at the University of Hull in the United Kingdom, and is a fellow of the Higher Education Academy, FHEA. He served as a visiting scholar at Columbia Law School and Columbia Center on Sustainable Investments. Dr. Lateef previously held academic positions at Obafemi Awolowo University, where he taught courses that included energy law, company law, equity and trusts, and Islamic law. His research focuses on corporate governance, international trade, and investment law, and sustainable development as well. Dr. Lateef is a member of the Society for Legal Scholars in the UK and serves on the steering committee for the think tank on white-collar crime and modern slavery in the UK as well. He holds a PhD in law and has been a qualified barrister and solicitor of the Supreme Court of Nigeria since 2008. Thank you so much, Dr. Musbah Lateef, for joining us. I would also like to read a profile, of Miss Islamia, as well. Islamia Abdulateef, holds a first-class degree in accounting from Obafemi Awolowo University, where she graduated as the best student in the faculty and the best female student in the university. This academic foundation, combined with her professional experience, makes her particularly adept at simplifying complex financial concepts and guiding clients through the intricacies of estate planning. She's a finance and trust professional at Coronation Trustees Limited, where she plays a key role in developing tailored wealth succession strategies for individuals, families, and institutions. Driven by a commitment to faith-based financial solutions, Islamia actively helps Muslim clients design Sharia-compliant estate plans that honor both religious obligations and legal standards. Thank you so much, Ajia Islamia, for joining us. And I will wrap up by quickly reading the profile of our host, Mr. Yemi Sadiq, who is also a panelist. Yemi Sadiq is a seasoned corporate and commercial lawyer, as well as an experienced trust advisor. He's a registered member, is registered with the Securities and Exchange Commission and as a capital market operator. And he has wealth of experience in legal and trusteeship services. He's as Managing Director of Coronation Trustees Limited. Yemi leads the firm's strategic direction, operational management, and client engagement, while ensuring sound financial oversight and strong stakeholder relationships. Before joining Coronation Trustees, he held key leadership roles, including as Managing Director and COO at Ava Trustees Limited, where he drove business growth and operational excellence. He was also at ARM Holdco and ARM Trustees Limited, and he played pivotal roles in deals exceeding 2.5 trillion naira. Thank you so much, my panelists, for joining us today. And I would like to start, by diving into the discussion with Dr. Musbah Lateef. Let me start with you, Dr. Musbah. In your experience, what is the most common misconception about Sharia-compliant trusts, and how can advisors address this? Thank you.
All right, thank you. Thank you, and good afternoon, everyone. I'm also happy to be here, and I thank Coronation Trustee for inviting me. And I think there cannot be any better time to discuss issues like this than now. And it is very important to emphasize that Islamic products around finance, have continued to become, popular as Muslim population, grow worldwide. So I think discussing this is quite important. Now, planning, generally speaking, for wealth succession is an aspect of Islamic law, which is, imposed on Muslims, because as steward of wealth, whatever Allah has, bestowed upon a Muslim, A Muslim is generally speaking a steward, what Allah call a Khalifa. And for that purpose, the purpose of being a Khalifa is to manage this asset for the benefit not of himself only, but also for those who Allah has, I would say, decree, to benefit from his wealth, and also particularly the society. So having made this general point, let me quickly say that, yes, there are quite many misconceptions about the concept of trust. And one of them, for example, is that you can use an Islamic trust, a waqfu, to bypass a wasiya, a will. The question here is that really correct? The answer is no. Now, a trust at best under the Islamic law can only complement a wasiya, because in the real sense, what a trust does is to allow management of assets, control and management under Islamic law. What a will does essentially is that a will takes effect after death. And essentially, it merely stipulates how the testator, wish his estate to be distributed, as the case may be. So to that extent, really, what a Muslim does with a trust is to achieve what we call sustainable investment, to continue generational wealth by allowing experts, people who have knowledge, regarding Islamic investment in particular, to manage, a portion of their asset. So basically, yes, it is not true that a trust can be used to bypass the Islamic will. The two of them can be aligned, but then they serve different purposes. Now, one of the misconception is also to say that the trust concept is not halal. That is also not correct. And the answer to that we also derive from the point I made earlier. As a matter of fact, al-waqfu, as the Arabic word goes, is an important aspect of Islamic tradition. The Prophet himself, sallallahu alaihi wasallam, is reported in a particular hadith to have said that when a Muslim dies, all his deed is cut off from him. I mean, I'm paraphrasing now, except three things. The first one is sadaqah jariyah, a continuous charity, something he has given which sustain goes on even after his own death. The second one, al-ilmu yuftafa bihi, a knowledge that he has passed. Maybe he's a teacher, or even the program we're doing now, the organizers, they have given an opportunity, for people to understand Islam better. So those who will subsequently watch this program, they would also benefit from this. And the organizer, in a way, would also take benefit. And then the last one is said, children that he left behind who say prayers for him. So from this hadith, it shows that from 1400 years ago, the concept of trust has always been part of the Islamic tradition. Therefore, the trust concept is not only a Western invention, but also a part of Islamic law to continue, I would say, wealth creation at the individual level, and also for development of the society, for justice, for fairness, and all of those principles that Allah has enjoined upon Muslim. Another misconception or myth, if you like, that I can recall now is, let me just stop there for now. Can you hear me?
Yes, we can hear you. Thank you very much, Dr. Yeah, we really appreciate that. I think what you said, especially about the fact that the concept of trust in Islam is about sustainable generational wealth. And I think that is a concept that we must take away from this conversation. When we are asking to have a trust, we are talking about sustainable generational wealth regarding investment. So people must take note of that, and we're going to take some of the questions as well. But whilst you are still on, let me quickly move over to Ajia Fatima Datijo. Ajia Fatima, thanks again for your very, very important and keynote speech. In your view, what core Islamic principles should underpin a Muslim's approach to intergenerational wealth transfer beyond the legal requirements of inheritance? We just want you to speak a bit more to the strategic importance of halal wealth succession. So what will you say are those Islamic principles that underpin a Muslim's approach to intergenerational wealth? So speak to us on that.
Okay, so one of the key things, I presume, and I think, we need to do is we have to have niyyah. You have to have a good intention overall. What is the actual purpose, of that wealth succession? What is the import? One of the most important thing is, as your intention matters in whatever you do. So before you start, the first thing that you need to do is to have an intention as to the reason why you are creating such. Another thing is purpose. You have to have that purpose in mind. What is the purpose? Are you doing it for the benefit of whose benefit are you actually doing it for? For your children, for the community, and whom, basically. The next thing is you have to also have knowledge in the sense that you have to have financial knowledge for you to be able to transcend, to have the foresight to transcend beyond generations. Because if you're limited, if your thoughts or knowledge is limited, you would not be able to see how that particular wealth can transcend beyond yourself and just your immediate generation. Another key aspect is you also have to have that, or rather impact that learning to your successors, that tarbiyah. You have to give them that knowledge of financial importance as to the reason why you're doing what you're doing, not just for your own benefit, but for their own sustenance and for them to be able to also continue it. And lastly, you have to ensure that you're not just doing it for the financial aspect. You also need to ensure that you acquaint them and also acquaint yourself that you're not doing this just for the financial gain it affords them, but as a continuity, as a sadaqatul jariyah, most importantly.
Thank you so much, Ajay. I hope we are all learning, all the participants that are here, I hope we are all learning. She talked about intention. You must have an intention as to why you are writing a will or the trust, why you are creating a trust. The purpose, you must know the purpose and the benefits. I think those are very, very key points that we should be taking notes of. But let me move to my sister, Islamiyah Abdulatif. Ms. Islamiyah, what do you consider to be the key elements that must be included in a valid Sharia compliant will, a wasiyah, and how are they different, from a conventional will? Are you able to help us with those insights, Islamiyah?
Absolutely. Thank you everyone for joining. Special thanks to our speaker for what she has been taking us through. I think she has said a lot of things. So I think this question is a very fundamental one, and the answer is simple, although it's deeply nuanced. So in Islam, the will, wasiyah, as Mrs. Datijo has explained, is not just a document. It's an Islamic fundamental. It's our responsibility. So some of the core elements that a Sharia compliant will would have is first Shahada and intention. Shahada is the declaration of faith. Shahada is on the tongue. Ashhadu an la ilaha illallah wa ashhadu anna Muhammadan abduhu wa rasuluh. So we need to first of all renew our Shahada, then also purify our intention. Next would be the appointment of an executor. It is very important that we appoint a trustworthy, a professional executor who is competent both legally in the jurisdiction where we are and understands the Islamic principles, who is able to help ensure that all our intentions are carried on when we're around and even when we're no more. So another one would be payment of death and funeral costs. As Mrs. Datijo has said earlier, the Quran in Quran chapter 4, verses 11 to 12, Allah was very specific about Faroid. That's the inheritance now. So debts and funeral expenses are taken care of immediately. That's a very fundamental concept. We'll also have wasiya. That's the will itself now. And the will we're talking about here is 1/3, as Mrs. Zatijo and Mr. Latif had explained earlier. So we're not, as Muslims, we're not left alone to say we want to give out all our assets to the way we like. Allah was specific about 2/3 of them. Then the rest 1/3 we're able to say where we want it to go. So we must ensure that it's just 1/3 that we're putting in our SIA. We also have guardianship for minor children, vulnerable beneficiaries. We must ensure that we name a wali, a guardian, who is able to put them through and ensure physical welfare and spiritual welfare. So I think these are the very fundamental concepts of wasiya.
Thank you very much, Ajia Islamia. I mean, I'm still going to give you time, so don't worry. You're still going to explain a few more items, but I wanted to just quickly up to our CEO, Yemi Sadiq, because I need you to speak a bit on estate administration and how we can navigate the path forward in this limited time that we have. So what will you say are the practical steps an executor must take to ensure a Sharia compliant and legally valid estate administration in Nigeria? I mean, Islamia talked about paying debt, fulfilling bequest. How do this compare as well to the conventional probate processes, especially when you also have to have a wali, or someone that will guide when you have underage kids you are leaving behind if you pass on. Could you help us with this?
Thank you, Dr. Oyewale, and thank you to all our speakers. I've been learning a lot. I've just been nodding my head since, when you think you know quite enough, and then you hear other people speak about the same topic, and then you find out that you probably don't even know anything at all. So thank you very much to all our speakers and for all your contribution. Now, to your questions as to what practical step must an executor take. In Nigeria, this is actually a very important question, because the executor, in effect, is the steward of the deceased final rights. The executor is the person that would ensure that the deceased final stipulation and their rights actually is brought to life. So if that role is mishandled, it's not just a procedural lapse. It could invalidate all the obligation owed both to Allah and also the beneficiaries of that particular estate. So practically, the executor must begin by securing the death certificates and applying for letters of administration or probate from the high courts in the appropriate jurisdiction. Remember, we're actually trying to now bring it into the valid administration in Nigeria. So you must ensure that you secure the death certificate, you apply for LOAs and probates from the high court. And this is, your legal license to act. This is actually what gives you that license to act. Now, from a Sharia perspective, this is how you would go about it. And this is divinely mandated. And I think Hajia Datjo had actually alluded to some portions of it. So the first thing, which is the Tajiz wa Takfin, which means you must settle funeral expenses. Hajia Datjo had said it's possible that somebody pays the funeral expenses on your behalf. But the first thing is settle all funeral expenses. The second thing is to settle all outstanding debts. Now, this is not just your physical debts. This includes your spiritual debts, which means your unpaid zakats, your missed fasts. And you might be wondering, how do you pay your missed fasts if you're passed on? I'm sure the scholars on this call can attest to something called a fidya. You can actually use that, basically your family paying for things on your behalf, and all your spiritual debts that you must have owed, and then you just hope that Allah actually accepts it. The next thing is for you to fulfill the wasiya, which we've been speaking about since, which is up to 1/3 of the estate and only to non-heirs, which I'm sure we'll still be speaking about as we go on. And then you can distribute the remaining assets according to the faraid shares outlined in Surah Al-Nisa 11 to 12. Now, for me, I think the key is balance. You cannot fulfill the legal obligations without neglecting the spiritual. You must harmonize both of them. And that's where the knowledge, the intention, and the competent guidance are critical. It's very important for you to be able to harmonize them. Once you're able to harmonize them, then I think you're very well on to ensure that your steps are practical in being compliant.
Thank you so much, Yemi. We are wrapping up in a bit. I would like to implore all participants with questions to kindly put in their questions in the group. In the Q&A session of the chats of the webinar. That's where we're going to take all questions, and we're going to answer some of the questions in a bit. I would like to go back to Ajia Fatima Datijo for some of your last words. For participants who may be at the very start of their journey, what practical first steps will you strongly advise that they take today to begin planning their succession in line with Islamic values? You spoke a bit about it during your keynote speech, but we'd like you to just emphasize and guide those at the very beginning, at the very start of their journey. What are the practical first steps you will strongly advise that they take today?
Okay. Thank you very much, sir. So just writing from what you've said, what you've summarized, what Islamia has said, and what Mr. Yemi Sadiq has said is the first and key important, and Dr. Misbah as well, the first and key important thing is to educate yourself on Islamic inheritance. You need to educate yourself on that, particularly faraid and the wasiya rules. That's one of the key things. The second thing is to create an asset inventory, what you currently possess. That way it guides you, which includes your debts, both physical and spiritual, just like Mr. Sadiq said, your liabilities, and a list of your beneficiaries. You should also write a Sharia compliant will, just as using the guide that Islamia just shared with us. I think before you're able to also confirm, I think we can take a cue from what she has given us, I would say the expo she has given us. You can start with that. You can speak to your family about your views and your plans, just sort of, get their own buy-in, right? Because you also want them to understand where you're coming from, because God forbid, if you're not there, they are also going to be the ones to ensure that, your wills are carried out in accordance to how you want them to be done. Most importantly, seek guidance from Islamic estate planners, like coronation trustees, right? And then lastly, also consider establishing waqf or trusts that can, precede you upon your demise. Thank you.
Thank you very much, Ajia Datijo, for those keywords. I think one of the most important ones I would say out of the 5 that you mentioned would be the one of educating oneself and also creating an asset inventory. From my experience, a lot of us, we struggle when it gets to creating our asset inventory. So I would really, really encourage us to ensure that we start doing that. No matter your stage in life, you actually need to know what you think you're worth, what you think you are owing, and what you are owed as well. So let's create that asset inventory and also align with all the other items. Dr. Misbah Latif, I would also like some final words from you on this point. Can trusts be used to support long-term charitable goals, such as Waqf or structured zakat distribution? And if so, how? Can you tell us how we can do that? And maybe while you are doing that as well, you can also guide us on how Muslim families will ensure their trusts do not override or contradict Islamic inheritance rules, especially when dealing with blended families or international estates. We have people all over the world now, that have assets all over the world as well. So how can Muslim families ensure their trusts do not contradict Islamic inheritance, and can trust be used to support long-term charitable goals? You have just 2 minutes, Doctor.
All right. Thank you. All right. Thank you again, Dr. Oyewale. Let me quickly attend to that by saying, first, the trust as a concept complements the wasiya and does not and cannot replace the wasiya. So the trust rather generally, serve the purpose of managing, I would say, complex, succession financial planning, if you ask me, because this is where you appoint expertise, not only who are knowledgeable about Islamic law, but who have the industry knowledge to manage assets in a sustainable version. So to that extent, we should understand that both the trust and the wasiya, they serve different purposes. Now, what can a Muslim do? Sorry, the second question again now. I was trying to take note of that. You are muted. Unmute. You need to unmute yourself, Dr. Yoale.
I'm okay. You can hear me now, right?
Yeah, I can hear you now.
Okay, I was asking, how can Muslim families ensure their trust do not contradict Islamic inheritance rules?
Okay.
And can the trust be used for the long-term goals of lack of? Yeah.
Okay, thank you. You see, one of the common, hadiths of the Prophet is where it says, innamal amal biniyat. Every action is judged by intention. Now, the application of that here basically is that, first, a Muslim must have a good intention not to set up a trust to override the fixed asset to has under the Islamic law. So if the purpose of setting up a trust is to, for example, give 1/3 of one's estate to people who are ordinarily not covered under the fixed, Islamic law of inheritance, perfect. So in a way, therefore, the will can actually be used to serve the purpose that Allah has designed it for. While the trust, on the other hand, can be used to achieve even greater purpose with even greater reward from Allah, community, family, sustainable wealth, and all of that. But generally speaking, let me conclude this way. You see, I had a first-hand experience of lack of planning or poor planning, I would say, over a decade ago, when a brother who worked with an IOC in Port Harcourt, he died at a very prime age of 40. He had assets, huge bank account. He had a business that was going, a pregnant woman with 2 children. Then he passed suddenly at 42. We were at Lagos State Probate Registry for 2 years, trying to get a letter of administration to sort his estate. Within this period, of course, his employment benefits, became frozen, his money in the bank account, and why everybody suffered in the family. For me, this is the real human cost of lack of planning and why it is very important for Muslims to do it today. And this is, I think, what the hadith you referred to earlier, Dr. Iwale, also buttresses, where the Rasul says, no Muslim who has something to bequeath should sleep for 2 nights without writing a will. So I think it is incumbent upon all of us to make sure we write our will, and more importantly, to engage professionals who can help us navigate these seemingly tricky waters. Thank you.
Thank you very much, Dr. Lateef. I think you've been able to hit the nail on the head. We have more than 200 people on this call. I think the call to action is that we must all write our wills, okay? And let us also set up trusts as well, okay? That lack of planning, let it die today. Let it end today, okay? Thank you so much, Dr. Lateef. Islamiyah Abdul Lateef, I would also like you to speak to us about some of the challenges, some of the common errors, or omissions you see given your work when Muslim families draft wills, and what are the practical steps that can be done to avoid them? Can you tell us, please, just in a minute or two, Islamiyah, please?
Okay, very unfortunately, it's very common that a lot of Muslim families make quite a number of mistakes when they set up their wills. So one of the mistakes is they don't follow the 1/3 principle, the 1/3 wasiya principle that I've been talking about. So a mistake would be that they bequeath more than 1/3 to non-heirs, or they restrict Farahid to less than 2/3. So this is a very common mistake. To solve that, we need to educate ourselves the more, as we have heard earlier. And of course, we also, at Coronation Trustees, we help, we provide recommendations and guidance on how you can strictly follow Sharia principles when you are setting out your will. We also see that some people leave out guardianship instructions for their minors or their vulnerable beneficiaries. So maybe because they are ignorant, or they don't just know. So what we do is we help them provide recommendations. We guide them on the importance of this. We also see that a lot of persons, they are nonchalant about it, whether because they don't care or whether because they do not know that it's even not just, you don't do it because you just want to do it. It's actually your duty as a Muslim. We also see that some people mix up wasiya and hiba. Hiba is gift, as Mrs. Datijo has explained. They are not the same. Gifts is different from wasiya. So education, very, very important. Another very, very common mistake that people make is not updating their wills when a major life event happens. Wills should be updated very regularly. There's no cast in stone time to when you should update your wills, but very regularly, especially when major life events happen, like when you get married, when you get divorced, God forbid, when you secure new assets, when you have children. It's very important to update your wills. So, yeah.
Thank you so much, Ajia Islamia Abdulatif. I mean, for your points. So I hope we've all heard some of the common mistakes that we make when we write our wills or our wasiya. We don't follow the wasiya rule of 1/3. Faraid, we mix it up. I think the most important thing is education, and I think we also need to understand that there are occasionally life-changing activities, as we progress in life. You are appointed, you get a new job, you get married, you get divorced, as she said as well. Whenever something material happens, try and update your will, and do not leave your heirs, especially the young ones, without guidance. Maybe some of us feel we are not going to die young, so I'm going to be, my kids will grow up, but nobody knows the day they're going to die. So please, let's do it properly. Thank you so much, Ajia Islamia. I would like to run through the questions. There are many questions, and thank you for bringing the questions in the Q&A. I will have our panelists try and answer some of them. Where they've been answered in the course of their presentations, I will skip them. So I will start by asking, Ajia Datijo. Question 1 says that half siblings and step siblings, are they eligible to inherit? And if your parents are non-Muslims, are they also eligible to inherit your will? So I would like you to speak to that, Ajia Fatima. But while you hold on for a second, I also want to mention, to take this question to Yemi, our CEO. Someone asked a question as to how Muslims can manage an estate within the existing laws of the Lagos State High Court. I mean, you heard Dr. Lateef mentioning how it took them 2 years, and in the process, the assets of our brother was scattered, or some of them were lost. So in the absence of a wasiya, what does Islamic law say in determining the value of an estate to ensure it conforms with Faraid principles? So I would like Yemi to answer that. And Ajia Fatima, if you could help us address the question of half siblings and parents that are non-Muslims. Thank you.
Okay, so generally, I would just go by the provisions of chapter 4, verse 176, and in talking about siblings generally inheriting. So siblings may inherit a deceased where you have absence of children. So, however, where you have children in the mix, siblings will not be entitled to inherit because obviously you have fixed shares and the shares would not accommodate the amount of numbers of people. So ideally, half siblings or step siblings are not eligible to inherit based on faraid, right? So also as it relates to parents that are non-Muslims, right? By virtue of disparity in religion, Islamic law does not provide for that. However, the option of making a will and bequeathing is where it comes through for, non-Muslim parents, whereby they're able to be afforded or gifted a few items prior to the demise of the deceased so that they are able to enjoy one or two aspects or wealth from the deceased estates. So it's definitely very, very, it's admonished, where you have, instances whereby you want to provide for people that ordinarily cannot inherit you, you take, the modes of, bequeathing or gifting, these people part of your wealth prior to your demise so that they can also benefit. But ideally, they do not form a party or rather a part under the faraid shares. I hope that answers the question.
It does. Thank you so much. But but before you leave the stage, Ajia Fatima, there's a question as to if your children are non-Muslims, either they revert or convert or whatever, are they also entitled to this? Where will they fall into? I know you've spoken to a bit of it, but can you just answer
similarly, because of the religion, the disparity in religion, right? You cannot inherit. Right, so it still goes for the same thing, whether ascendant or descendant, being a non-Muslim, they are unable to inherit. However, what you can do is to provide for them, within your 1/3 share that you're able to, sufficiently bequeath or give out.
Okay, thank you very much.
If I may just quickly add to that, I agree with Fatima completely. I think the question also underscores one of the advantages of creating a trust. Yes. As a Muslim cannot bequeath to those people because of religious disparity and all of that. A trust can actually be used, I would say, effectively to cater for them, what we call inter-vivos trust. A trust in the lifetime of the testator, as the case may be. And I think that's one advantages of the trust also under Islamic law, which is quite, halal.
Thank you very much, Dr. Latif. Whilst you are online, Yemi, please still take note of the questions that we've asked you. But there's someone that asked a question that writing a will only solves 50% of the problem. You still have to take steps after the death of the testator to obtain a probate of the will. I thought the whole idea of trust is to circumvent these bottlenecks. So can you throw more light on this? You've said something now, Dr. Latif. Is that going to be your answer to this question as well?
Okay, not exactly. Well, basically, like I've said earlier, the concept of trust does not ordinarily, seek to circumvent the wasiya and should not for a Muslim who, is well-intentioned. So, but the issue of probate, I think, is one of the disadvantages about will generally, whether under Islamic law or whether under the conventional law or whatever. But the basic thing is that when you have a trust in place, after the death of the testator, the trust becomes immediately implementable. And if it had been existent even before the death, it simply continues. Just like the example I gave earlier, when the brother died, if he had had a trust in place, his abandoned project would not have been abandoned. Some fund could have been easily accessed to cater for his pregnant wife and the 2 young daughters. So generally speaking, I think people should understand that the wasiya and the trust, they are only complementary. Neither can replace the other or even circumvent the other. And a Muslim, as I said, should be well-intentioned not to use a trust to circumvent the will.
Thank you. Thank you so much. Yemi, I'm still going to come to you. Maybe you should answer that question, but there's also a question here that I know you can answer.
Sorry, can you take that question again? I think if I remember, you said someone asked the question that how do you manage estates within Lagos?
Yes. I'll repeat the question, but there's also a question here that says, can we have a template to guide us in the preparation of asset inventories? So that's directly to you. Then let me
Oh,
repeat
yes,
it.
we will definitely share this with our participants. When we're sending the slides to them, we'll send them a sample of what a typical asset inventory would look like if they wanted to actually schedule their assets.
Cool. So how can a Muslim manage an estate within the existing laws of the Lagos State High Court?
Okay, that's actually a very interesting and practical question. Being that we are in a session where we're talking about estate planning within the Halal framework, and the administration of estates law in Lagos is a secular law. So, it raises the question, how do we go about this? Now, if you're a Muslim residing in Lagos, the default legal framework is based on the English common law, not Islamic law. We need to actually just put that on one side. So it is important for us to see how we can then understand and apply it. So the short answer is this. While Lagos State does not automatically apply Islamic inheritance rules, which is the faraid, a Muslim can still ensure that Sharia compliant estate management works through intentional planning. And that is why we are having this session. Where there's no will, the family can still petition the courts to apply Islamic distribution with the consent of the heirs and the guidance from scholars. So again, I'll say that again. Whilst Lagos State does not automatically apply Islamic inheritance rules, which is our faraid, a Muslim can still ensure that they create a Sharia compliant estate management, through a proper planning. But where there is no will, where there is no wasiya, the family actually can petition the courts to apply Islamic distribution with the consent of the heirs and guidance from the scholars. And the reason for this is simple. You're able to actually tell the courts and say, look, this person in their lifetime, this is how they lived, this is how they've always operated, this is what they want. And that way, the courts might acquiesce or not. Now, again, just very quickly, Dr. Yewale, since we're talking about the Lagos State rule, the current law in Lagos State is the administration of estates law, and it applies to people that die testate, that is with a will, and for people that die intestate, for people without a will. Now, if there's no will, the estate is distributed under the English rules of intestacy, not faraid. So it's very important for us to know this. So this means that the spouse gets the personal chattels and a portion of the estate. The children and the spouse share the residue equally. There's no recognition of a male to female share differences or extended families, unless there are no children anyway. Now, this is clearly different from Islamic inheritance law. Now, the main thing is we should be asking ourselves, what can a Muslim do to ensure Sharia compliance? There are a couple of things. Remember, this is a will. So there are two situations. First one is during our lifetime. During our lifetime, there can be proactive planning, which means let us do a Sharia compliant will. There are people on this call that can discuss it with you. Mrs. Datijo is there. Dr. Oyewale is there. They can explain. Coronation Trustees is there. We can explain, clearly state what your estate is and how you want it to be distributed. And then your wasiya should include an Islamic distribution clause. Then you appoint an executor who understands both Sharia and the local procedure, and then the wasiya itself. As Dr. Misbah also said, set up a trust. Even though one cannot negate the other, set up a trust or use hibah, as Mr. Datijo said, give gifts during your lifetime. Or if you like, create a family constitution. I've seen that happen a lot. Now, remember, this is during your lifetime. Now, the second situation is only one, which is after death. At this point, there's no will. Now what? If a Muslim dies in Lagos State without a will, family can apply for letters of administration from the probate registry. In doing so, they must disclose all their assets, they must do bank certification, they must, the next of kin can apply, not necessarily benefit, but apply. Normally, the distribution will follow the Lagos State intestacy rules unless an alternative arrangement is presented. Now, the family can unite and agree to distribute the estate according to Islamic rules, which is faraid, which means all heirs must agree that in writing. There must be a fatwa or an advisory from a recognized Islamic scholar or body. For instance, Marble Capital is one of an Islamic advisory organization that has relationships with different Sharia advisors like NASFAT and the likes, or the Sharia Council. All those things can be presented as support and guidance. Now, there could also be a private family settlement agreement, which can be drafted or signed, reflecting the faraid shares. And then at this point, the court may then issue a letter of administration, right? And the estate can be distributed in line with the agreed settlement. Now, it is very important for me to mention that this doesn't change the law.
Yemi,
you know,
we need to wrap up. So,
all right, thank you.
I would like Dr. Lateef to answer the last question, which is that can you create a trust for an unborn child, and should a spouse be named as a trustee in a wasiya?
The answer is absolutely yes. And scholars, are agreed on this. An unborn child does not fall within the realm of what we call garar, uncertainty, which is one of the principles that Islamic law of finance actually prohibits. So yes, just as you have under the conventional or common law principle, an unborn child, a child who is being expected, can be catered for. You can have provisions for them. And of course, a spouse can also be appointed as a trustee, just as you have under the conventional or common law. Remember, the trustee in Islamic context is generally for stewardship, not exactly for ownership as you have under the common law. So as a custodian, therefore, the trustee is more or less like an agent, who manages the property then for the benefit or whoever the beneficiary are, or for the purpose for which the trust was created, if it is a workful trust for public benefit. So yes, the answer is yes.
Thank you.
Wallahu alam. All right.
Thank you so much, Dr. Lateef, and thank you so much, Ajia Fatima, Ajia Islamia, and of course, our CEO, Yemi Sadiq. This has been an incredibly rich discussion. Thank you to all our panelists, and thank you to all the participants as well for your Q&As. We really thank you for sharing your expertise with us today, and we also appreciate Coronation for actually giving us a platform, to share and discuss a very, very germane topic regarding halal trust and wills. I would like to let you know that a recording of this program and also the slide deck will be emailed to everybody that registered for the program. And if you still have any questions, please contact Coronation Trustees at trustees@coronationt.com. coronationt.com. Okay, I would like to hand over now to the head of trust services, that is Mr. Adelekon Balogun, or at Coronation Trustees, for final remarks. Adelekon, the floor is yours. But to everybody here, thank you all for joining us this afternoon.
Thank you,
Yes.
Dr. Yoli.
Good afternoon, everyone, and thank you all for taking out the time to attend this session. It's been a wonderful and engaging section, and I believe this discussion and conversations we have to do further deepen Islamic finance and Islamic estate planning in Nigeria. And to our keynote speaker and panelist, we can't thank you enough. We appreciate your thoughtful contributions, and your insights have been so nice. It has brought clarity, depth, and guidance on this important topic on how we need to plan our wealth and ensure that we are doing things in line with the tenets of the Quran and in line with the Sharia principles. And then our audience too, thank you very much for joining us today. And we hope you are living today with a fresh perspective and tools that you need to start to strengthen your estate planning and to start your estate planning journey. And then at Coronation Trustees, basically, we are committed to helping individuals and families to protect their wealth and preserve their legacy in line with faith and Islamic principles. And if you'd like to learn more and speak more, our team will be reaching out to the attendees to help you plan your estate and to start the conversation. So until we meet again, I will say that you need to stay informed and stay committed to value-based legacy planning. And then on your screen right now, there's a barcode that goes through our portal where you can start the conversations, and if you fill out the form, we'll reach out to you and we'll help you furthermore for the next steps. Yeah, the barcode there. So if you scan this barcode, it's going to go straight to our trustees portal. So, and also we have an investment academy that speaks to different aspects of trust products and all. We have the Islamic courses there. We can further go to the investment academy and you're able to learn all other things that we'll not be able to discuss here. But till we meet again, thank you very much for attending.
Thank you too. Bye-bye.
Thanks, everybody.
Thank you very much. Thank you, everyone. Thank you. Have a very wonderful day. Thank you very much.
Thank you, everyone.
Bye.
Bye-bye.